West Seattle. West Seattle was the place where I landed when I moved from Chicago back in 1988-89, and I was a West Seattleite for about 25 years. So this is home. I love West Seattle, and it's just nice to be back. I like being with my friend Ruthie and Sue. It's just nice to see, frankly, people from the past that bring a lot of smiles and joy to me. So again, it's nice to be here. I also want to take a minute to acknowledge Dow Constantine, who is another great West Seattleite. And Dow is, in my humble, nonpartisan opinion, probably one of the greatest King County executives. We happen to be lucky enough to serve at the same time in King County. I was a King County Superior Court judge before I went to the Supreme Court. But the special thing about Executive Dow Constantine is he was so always unassuming about so many different things. And one night, he says, "Would you marry me and the love of my life on Halloween in 2013 at the courthouse?" It was a true privilege and honor to do that. Dow, we're delighted that you're here. I know that you have another meeting. He, as you may know, is now on the Sound Transit Board, and he's been appointed also as a member, I think, of the Regents at the University of Washington. So, Dow, thank you so much for everything. So I'm here to chat with you about your state Supreme Court. And it's pretty ironic that I am here just shortly after announcing my own retirement. And people will say to me, and they do all the time, "Why are you retiring? Why now? You seem young." And I want to start off by saying I'm not so young. I hit being a judge 25 years this year. And it really gave me the opportunity to reflect on my life, where I was going, and what comes next. And those of you who have ever worked for the state, you know there's a number that you hit where it's not worthwhile to stay. So I've been in our state system for 32 years. And I really have to just say that a colleague of mine, Justice Susan Owens, died last year. She wanted to be the first woman to retire from the Supreme Court at the mandatory age of 75. She made it to 75. She retired last year, and then 3 months later, she died. And it broke all of our hearts, and I said to myself, I'm not going to do that. I am not going to work until I die. And that is an ethic that many of us grew up with, right? If you're from a working class community, the thought of retirement was something almost that we didn't talk about. It was very difficult to achieve. And you think about working to the end, and I thought to myself, I'm not going to do that. My generation is privileged enough to be able to say, I can stop working, and maybe I can do some other things. So I'm hoping to continue to teach at Seattle University School of Law, where I am an adjunct part-time faculty member. I'm hoping to reinvigorate my volunteer work. I'll be looking for a Rotary to join, probably. But I don't have a list of things to do. I want to be. I just want to be a person again, and I'm looking forward to it. So December 31st is my last day. I just have a statutory 60-day period to finish opinions, and then I will be retired from the bench, and happily so. So let me tell you something about our court, because not a lot of people know much about the Supreme Court. So first of all, it's important to know that the court system in Washington State is not a unified court system in the sense that we're all separate from one another. So there's a Supreme Court, and then there's the trial courts, right? There's the Superior Court of 53 different counties. We're not unified in any way. There's a Chief Justice on our court, and that's a really name and title only. She has no authority over any other judge. Many municipal courts as well have really emerged. They're all independent. So other states have moved to a unified system. California, Oregon recently, where the system is one court system and every judge does everything. And some of us, and some legislators also, believe that a unified court system might be a good thing for the state of Washington now that we have grown, now that we have an identity, now that local communities own us. Maybe it's not such a bad idea. And here's one idea that I'll just pop out for you to think about. And the difficulty has been, people will say, well, gosh, you know, I have a matter that I want to have heard, and maybe it's a ticket you want to contest as you were driving through Seattle, but you might live on the east side, but it requires that you travel back to Seattle to resolve it and deal with it among the many courts that exist on the east side. This is just one example, is that we're unable to adjudicate matters that perhaps a unified court system would allow us to adjudicate the closest court to you. If you live downtown, you're downtown. If you live in Bellevue, you're in Bellevue. If you're in South King County, you go to that courthouse. And the idea of being able to have everybody working in one direction might be a good thing. The reason why the legislator is looking at this, the legislature is asking the same questions. What might be more economical? What might be more efficient if we had one set of records that we all could look at? Because we have judges in Spokane who can't look at a record from Seattle. And you might say, well, why would they want to look at that? Well, because there's somebody who has a domestic violence protection order that's been issued in Spokane, and they moved to Seattle, but the judge doesn't know what the order says. The inability to have a unified system of records and discussion, again, is maybe another reason why we should start to look at it. I probably am not going to see this in my lifetime. I just want you to know why it's important to understand our inefficiencies, why it's important to understand that every court is independent right now, but there's discussion about something different happening. So the courts that we're talking about really include the Supreme Court. The Court of Appeals is one Court of Appeals, but three divisions, and that is they sit in three different areas. We have a Court of Appeals in Seattle, Tacoma, and then we have one on the east side in Spokane. Again, it sits as one Court of Appeals, but three different sites, right, in order for people to have access. The trial courts, as I just mentioned, we have the Superior Court, and each county has their own Superior Court, but then again, each municipality. So we have King County Superior Court that has two sites, and then one juvenile division, and then we have all the municipal courts. So when you think of a city, most of them have their own municipal courts. Seattle has its own municipal court, Federal Way does, Kent. Again, you can name the entities. Mercer Island, people have their own local courts. Separate and not one. So at one level, what difference does it make? It means we don't direct judges and resources. It really relies on collaboration, cooperation, and really persuading others to try to come together and speak as one. So who's on your Supreme Court? We started with Justice Stevens, who is our Chief Justice. She has been on the court for 17 years. We have Justice Charles Johnson, who is one of the longest serving justices in our state's history. He's been on the court for 34 years. He will be retiring next year because he's hit the mandatory age of retirement at 75. We have Justice Barbara Manson, who's been on the court for 32 years. And she's thinking about retiring because she's 73 now. She's going to be hitting that 75th year soon. And I keep inviting her to join me in retirement. Then we have Justice Stephen Gonzalez, who some of you may know because he's been very active and enjoys coming out and meeting with individuals. And Justice Gonzalez has been on the court 14 years now. We have Justice Gordon McLeod, who's been on the court, and I want to say she's been there, I believe, 13 years, close to 14 years. We have myself, who's been there 11 years. We have Justice Raquel Montoya Lewis, who is the first Native American justice on our state Supreme Court. And then we have Justice Helen Whitener, who was the first Black woman on our state Supreme Court. And then we were recently joined by Justice Sal Mungia. Justice Mungia was just recently elected, so he just began in January. His own background in terms of his own ethnic makeup is Japanese and Mexican. So when you look at your state Supreme Court, it's pretty gosh darn diverse. And it's really something to be proud of. When we talk about this with other judges around the country, people think that it's engineered. And I keep saying to everyone is we are nonpartisan elected officials in the state of Washington. We are elected by people in the state of Washington. You might start at some point by having been appointed, but you immediately stand for election. And there are people who would say, do you run by district? And we'd say, no, the whole state. It means that each one of us has had to travel across the whole state, and I went to every single county when I ran because I thought it was important to meet people that I would never meet and for them to meet me. So the engineering of our court, I keep saying, is by the people of the state of Washington, not some individual who is deciding what we look like. My replacement, I am told that the governor intends to announce my replacement by December 1st, or maybe even around Thanksgiving. Interviews are occurring now. Anybody can apply. The only requirement is that you have practiced law for 5 years. So my understanding is the governor has had a robust pool of applicants. And again, they're hoping to announce by December 1st. So I'm looking forward to that. It means for me hurrying up and emptying my chambers. We are back in the Temple of Justice. Now you might say, well, what do you mean back in the Temple of Justice? Well, we left the Temple of Justice when COVID hit because the building really didn't have the circulation of air at the time that was required. And so we moved into some offices in Tumwater, and then the legislature at that time appropriated funds for us to make some essential repairs at the Temple of Justice that were really critical in terms of our return. And the first was potable water, because we haven't had potable water for about 20 years. We didn't have heat. Each one of us had little heating machines in our offices at the Temple of Justice. It's a building that is the oldest building on campus. It's beautiful, it's marble, but the legislature appropriated some $17 million for us to redo the lights, look at the water system, and bring in heat. So after being out for COVID for some time and the repairs were done, we moved in October, last October. So it's nice to be back at the Temple of Justice. It's nice to be back in a beautiful, wonderful courtroom. And I invite each one of you, if you haven't been there, come, if you're even driving someplace else, stop in Olympia and come and take a look at the Temple of Justice. It's a beautiful building. The library is open all of the time. The courtroom is always open for viewing. And it truly is gorgeous and beautiful. So I invite you to do that. Bring kids. If we're in session and justices are there, I can tell you that all of the justices love giving kids tours. It's really important to us that they understand what we do, who we are, and so we'll give them a tour. So I invite you to come to the Temple of Justice. People often will ask us, well, what's the court doing these days? Because the Supreme Court of the state of Washington has developed a reputation nationally, not only because of what we look like, because of what we have done. And a seminal turning point in our court was in 2020, shortly after all of the civil unrest in regard to the murder of George Floyd. Judges around the country were wrestling with what is it that courts should do. Because for the first time, at least in our era, we had not protests at the courthouse, but people protesting us, judges, the criminal justice system, law enforcement. We were the target of so much of the anger, and it's because so many people in the community felt no justice comes from you. No justice comes from this system of justice that calls itself justice. And so I remember at the time, a lot of our judges were saying, what do we do? We have security issues, and our Chief Justice was really just back from a national conference, and I was driving out of the parking lot at the Temple of Justice, and she said, you know, we need to do something, and we need to say something. And the only problem is, right, is that judges don't have press conferences. conferences, like the other branches. We don't get up and say, well, we'd like to, we just don't do that. We speak through our opinions. We speak through decisions. And so we didn't know what should we do? And we decided as a court to write a letter. And we wrote a letter to the legal community, primarily to judges and lawyers and to those who work in the legal system. And it was a letter that has now become quite famous. I brought copies that I can leave with you, but it's also on our website. And it was a letter asking everyone and committing ourselves to undertake the task of undoing racism in our system. Specifically recognizing the injustices that have been committed specifically against Black Americans. And we committed ourselves to education, to teaching, to training, but probably the most important thing was to acknowledge that it exists. And we did that in the letter. We sent it out, we didn't know what would happen, and judges all of a sudden responded by saying, thank you, because you just gave us permission to say the same. You gave us permission to reach out to people and to communities to say, help us heal, help us figure it out, help us work this out. So it was a really important moment. The other thing we did in this letter is we pledged to look at our cases when they came and to ask harder questions about race that we haven't asked before. So a simple stop and search case suddenly became one that we might say, well, gosh, is race relevant in this situation in terms of when this young person was stopped? What time were they stopped? Where were they stopped? Why were they stopped? And we thought we have got to incorporate those questions into our analysis, and we continued to do so. And that's what has put us on the map, if you will, is using a lens to ask hard questions about ourselves and saying, we pledge to fix this. We pledge to invite people to continue to help us resolve these questions that are difficult to resolve, and we don't do it by ourselves. So a lot of our opinions continue to be published by other courts. We still remain the second most cited court in the nation. The first is California, and then comes Washington State, which is pretty darn good, given how small we really are when we're compared to other states across the country, including New York and Arizona and other states. So finally, let me just say, the one thing that we are responsible for, even though we're not a unified court, we are responsible in terms of the system of justice, the administrative side of our work, and that is we promulgate court rules. So everybody does have to follow the court rules, and that is one way to try to continue to ensure due process in everything that we do. We have our cases that every judge pledges to follow. They take an oath, right, to adhere and to honor the law. We dispense the common law, and that is, right, we have statutory law and the common law, and judges are bound to follow it. We have administrative work through our commissions. We have a commission on gender and justice issues. We have a commission that's called the Minority and Justice Commission that continues to look at, again, issues related to race and poverty. We have an interpreter commission that is working very hard to ensure interpreters are available across the state. And so we pledged up, right, our ongoing analysis and reflection in light of today's world. You hear the debate of different judges. Are you an activist judge or not? Or do you think that time stands still? And for our court, all 9 of us have said, nothing stands still, right? And the intellectual gift that we bring is reflection and analysis in light of today, in light of what people need, in light of what the issues are that you bring to us, because we don't go and pick things, people bring us cases. You decide what the issues are. Lawyers decide what it is that the Supreme Court should hear or not. And it's out of that ongoing reflection and analysis that we really hope at the end of the day, right, that we're doing some justice. It's a quick snapshot of your court. There's a lot in there that I would love to tell you about in terms of how we make decisions and what we do. But because of the brevity of time, I'd rather just open it up, have you ask questions, and invite you to come. Yes?
What advantages of not having a unified court system?
The advantages of not having a unified court system are the independence of each court. And each court will say, because we're so attached to our community culturally, it is better that we don't have a unified system. Nobody wants to give up control. We have judges who say, I will not. When I was on Superior Court, they would say, I am not doing a misdemeanor case. I'm not a district court judge, right? I don't want to do DUI cases. I don't want to do theft cases. I want to do complex civil. So if we had a unified court system, the presiding judge could assign me to do those other cases that I don't want to do. Control and power. And it's a legitimate concern, and yet we've been told by California that judges get over it. That they recognize, right? They got to do it, they're going to do it, and then they recognize how much it's really a lot the same, and that you're still serving your community in some way. So it might not be the most intellectually stimulating case, but it's really important to the people who are there. Right? So that was the biggest thing why judges push back. I'm not doing those kind of cases. I don't want to do that. Yes?
Do you have any comment on the elections in New York?
Do you mean the election of the mayor? I cannot comment until after December 31st at plus 60 days. I am nonpartisan. And, you know, really, judges are not permitted to comment on political matters, and we retain that as much as possible. You know, and some people would say, well, gosh, everything you do is political. It does have political consequences in terms of what we do. But we're really blessed in Washington State to be a state where judges run nonpartisan, non-political. And that's not true across the country. In Illinois, you run as a Democrat or a Republican. In other places, you do that. I don't know how you do that as a judge, frankly. So I can't comment. I have personal views always about everything, but I really honor that pledge to not, so I can't.
You did very well.
Morning, or afternoon now. The harder questions. Who's running the secret shadow court buried inside of the ISIS detention center in Tacoma?
Yeah, there's many. First of all immigration matters are federal matters. And so it really is, and I really appreciate the question, because most people don't really see that there are two court systems, number one, right? It's a total federal system and a total state system. When we talk about the Constitution, there are 52 constitutions in this country, right? I mean, there is not, every single state has its own constitution. Totally separate, parallel running, federal courts, parallel. Under the federal courts, right, they get to hire administrative judges who are not Article 3 constitutional judges. They are administrative judges who run the whole immigration system. And so I have to admit, we never talk to them, we don't know them, we never see them. We have dinner in Western Washington. The judges get together with federal Article 3 constitutional judges. Because we know one another and we know what is happening. But we do not know anything at all. And I am confident that if I even requested as a state judge to enter into a detention center, I would be denied access. I have to just tell you, I know as much as you know, or maybe even less in terms of the immigration courts inside a detention center. But even more importantly today, even the one downtown in offices and in administrative courtrooms, we just don't know. A lot of judges have lost their jobs, those administrative immigration judges. And so there's a lot of change there, but we run parallel, and really there's no connection other than the United States Supreme Court gets to visit our decisions only when we rely on federal court. When we rely on our state constitution, they do not have any legal right or any power to overturn us or to opine on what our state constitution means. So a trend in state Supreme Courts around the country, people are saying, make decisions based on your own state constitution. If you do not want federal review, rely on your state constitutions. Final thing I'll say about this is Washington State is way ahead of the game. We had a justice in the 80s, Justice Utter, who was committed to helping our court because he could see into the future, and he said, we must develop our own jurisprudence around our own state constitution. So we've been doing it for a long time, and we don't start from zero, which many courts are right now doing. We have a robust history of interpreting our state constitution outside of the federal constitution. We have said individual and privacy rights in the state of Washington are primacy rights here, which is why it's enshrined. It is enshrined in our Constitution. Our court has said it more than a million times, over and over and over. Federal protection is here. State protection is here. And primacy in the state of Washington is our state constitutional law. And people need to appreciate that as Washingtonians. We don't start from the beginning. We've been doing it a long time. That's a long answer to a really hard question. Sorry about that.
Hi, I practiced law for 40 years and retired 3 years ago. And I was wondering if you could talk a little bit about the budget of the courts as compared to the other branches of government in the state of Washington, sort of how they break down. You may know the specifics, but...
Yeah, we are 0.0%. That's the whole court system. And the way our budget is approved is it goes to the governor, and the governor submits it to the legislature. And it's 0.08 of the whole budget, the entire state budget. We have continued to say, can you give us 1%? We would be happy with 1%, and let us decide how it's allocated so that the fight about the money is among the courts. Not everybody running to the legislature and lobbying for how the 0.08% is going to be allocated. And right now, everybody's competing with everybody else, right? District courts are fighting with Superior Court fights with another Superior Court to say, no, our drug court's more important than your drug court, or this is more important. And we've continued to say, and Chief Justice Stevens has said, her main point that she really wants to work on as chief is to say to the governor and to the legislature, just give us 1%. And just let us decide how we're going to allocate it so that the judges are fighting among ourselves, right? So that we could convene and say, what's a priority for our courts? Let's pretend we're unified and work together, right, on our priorities. So that's the goal, but you can see how small it is. It's very insignificant to the big state budget. The very sad thing that we have been working on that has made it a little bit of a sore point with some is we also do not believe that you fund the courts through fines and fees. Every governmental office, you can go in and ask your elected official to do something for you, but you don't have to pay before you go in. You don't have to pay to access the services in the same way. And in court systems, if you want a trial, right, you're paying a jury fee, and if you want this, then you got to pay more, and you're paying to access the system of justice. And for us, in terms of sanctioning criminals, people say, well, not everybody has to go to jail, and this is true. But then what's the sanction? Well, I'll fine you $1,000, or I'll fine you $5,000, or I'll fine... I mean, it is a cash-run system that our judges now have said, this is not good. This is not good for society. It's not good for people to see us as the cash register to services. So there's been a lot of pushback, and there's been a lot of change. But then we have pushback from local governments who say, well, then how are we supposed to fund you if you don't, there's not a cash system, how do we fund it?
All right, please put your hands together for